is in contravention to the current case law, and I have since had a secondary rabbit hole of spiraling into that section of case law of the negligence. I think what he was aware of, he responded to, and that's certainly something that would, I acknowledge would be appropriate for a fact-finding hearing contemplated by a just cause hearing, but as it relates to the due process concerns and the lack of specificity, I just think when you're saying he didn't review these MDT messages, so that led to this toxic environment of harassment, is just so difficult to defend, especially when there's not more given to that harassment occurred, and we're not disputing that it did, but just whether or not those 24 to 30 officers said that Captain Lapine knew about it or should have known about it. That's what we want to get at. It's just a matter of, they can weigh the evidence, but as I'm, trying to follow their logic, it's been incredibly difficult to see how Captain Lapine can be individually responsible for so many officers' conduct that I'm not even aware of, because I'm not even able to have access to that information. So again, the timeline of how this has gone down is problematic. I will just sort of defer to my exhibits that have been submitted into that. I also would note that the officers who sent the MDT messages at issue in the charging lane. I also, since filing this motion, became aware of some information regarding issues with Officer Jantuan. It's my understanding, and I am waiting on verification of this from the department via an open records request, that she subjected the department to liability in a very more direct way than what is being alleged here. She failed to properly handle a call regarding an intoxicated person at the Hyatt. Also made derogatory comments about coworkers. For all those violations, it's my understanding an oral counseling register was recommended, which is just documentation of an oral warning. And I only mention that because it's concerning to me that her attorney has since told me that the details of the settlement restrict who she may speak to and what she may say. So I'm very concerned about that portion of this, because so much of the department's case rests upon her characterization of a conversation she had with Captain Lapine, which he has very different recollections.
Themselves are sufficient. They contain sufficient detail to apprise Captain Lapine of the subject matter of these proceedings that are against him, i.e. the MDT messages that he failed to review and respond to.
213 actions or law enforcement disciplinary matters, some of those cases that the department cited while their Seventh Circuit cases, they just weren't specifically on point as it relates to the disciplinary matters. And again, with the administrative bottleneck, I mean, that's something that's sort of self-created, and it just sort of doesn't seem very fair, or that there's a fair procedure happening when you're denying Captain Lapine rights to enforce other people's rights. So I think that that's a huge hole in the department's analysis of what's the appropriate outcome in this case. Again, I had asked the commission to find that the pre and post deprivation proceedings have violated Captain. While I appreciate that the commission has scheduled